Shall we start? Start defining me 2 clause 52 first. We'll start with the next topic. What is 252? What do you mean by listed company? Am I required to get all my securities listed? Am I required to get listed in every stock exchange of India? I have to get listed in any one of them or all of them? What do you mean by listing? Simply speaking, layman language, making my securities available on the stock exchange. What do you mean by stock exchange? The layman wordings of stock exchange was stock market. It is a place where you can buy an vegetables, shares. If you can buy and sell shares in a particular place, it is called as stock market, the stock exchange. So give me the definition here. Listed company means, drafted, listed company means a company which has any of its securities listed on any one of the recognized stock exchange. Stock exchanges, are they run by government or private bodies? Private bodies, but they have to get a license. License under which act? SEBI and SCRA. What is SCRA? Securities Contract Regulation Act. You have to get a license from SCRA. Once you've got the license, you can do the business of stock exchange. Give me the listing process as well. When does a listing happen? Everything linked with prospectus. When does a listing happen? After prospectus or before prospectus? But when does the process start? Before prospectus. Before the issue of prospectus, the company should enter into an agreement with a recognized stock exchange and obtain what? Technical word, in principle approval. Once the in principle approval is obtained, then can we issue the prospectus? Can we allot the securities? After allotment is completed, then we'll get what approval? Final approval. Once we got the final approval, the listing actually happens at what point of time? After the issue of prospectus, but the process starts before the issue of prospectus. In principle approval is a post condition or pre-condition. Then we started exceptions as well. How many exceptions are there? Draft the sentence first, then we'll go for exceptions. How many, what's the definition part? Start. Listed company means a company which has any of its securities listed on any one of the recognized stock exchange, but there are people are intentionally wanting to be recognized as a listed company. We excluded certain companies. First, we'll start with which company? Public company, which has not listed its equity shares, but have listed what securities? Convertible or non-convertible? Non-convertible debentures and non-convertible preference shares. Issued on what basis? Private placement basis. Have been listed on the recognized stock exchange. Second, a public company again, but this time they have listed what? Equity shares. But the problem was they have listed it where? Proper word, in a stock exchange in a foreign jurisdiction. If the same equity shares were listed in Indian stock exchange, I'll call it as a listed company. But they are listed, but listed where? In a stock exchange in a foreign jurisdiction. And third category was which company? A private company, which has issued what securities? Non-convertible debentures on what basis? Private placement basis. Even though it is listed, it will not be considered as a listed company. Then if you are not a listed company, obviously you are a unlisted company, but there is no definition given for it. Then what else have we done in the morning session? Dormant company, Nidhi company. Dormant is enough to revise, the rest of it is fine. Dormant company, fast amount. Dormant company, how can you be defined as dormant company? How many ways are there? Two. Either you can be a dormant, you get the status of dormant company from the beginning, from the date of incorporation, or you can attain it even after incorporation. Start with from the date of incorporation. Dormant company means a company which is incorporated under Companies Act 2013. Not for today, but for a future project, but it is holding what? Asset or a intellectual property rights, but it is not having any significant accounting transaction. If it is having a significant accounting transaction, that means it is actually doing business. If it is doing business, can they get the status of dormant company? But whether every accounting transaction is not allowed or significant accounting is not allowed. What is significant accounting transaction? Is it defined? No, what is defined? What is not a significant accounting transaction? Then we had the second category where you are calling yourself as inactive company. To be called as inactive company, you have to satisfy how many conditions here? First condition, there is no business conducted. Second, you have not filed. Filed what? Financial statements and annual returns. Give me section numbers if possible. Financial statements 137, annual returns section number 92. Then the last category, you have not having any significant accounting transaction for how many years? Last 2 years. Nidhi company, quickly run through that amount. Nidhi company, can they accept deposits? Can they lend money? They can accept deposits only from. They can lend money only to. There's a reason it is also called as a mutual benefit society. To become a member, you have to purchase how many shares? Mere amount of 10. You can become a member. Now this Nidhi company has two reasons why it is incorporated. First, it will inculcate the habit of cost savings as well as cost thrift. Two categories. It will reduce your cost and it will also habituate you to get savings. Should you do savings? Your article income, what happened? Always remember this, whenever you start earning, let it be your article income, let it be your regular income, whatever you get. 20% of everything shall go into savings. Mandatory rule, amma, every penny you earn, 20% shall go into. We have zero income, sir, so we are saving money right now. How much percentage should go into savings? 20% mandatory. Whatever income you are earning, let it be 10 rupees, let it be 1 crore. 20% should always go into savings. That savings doesn't mean that you'll keep it in your bank account. You're smart enough to utilize the money correctly. You're not going to keep the money idle in a bank account. Rather, you'll make a investment. Investment in where? Lottery tickets? No. Make a proper amount of investment with your 20% of savings. I'll come back. Let's incorporate the company finally now. We discussed this 3 stages of a shareholders' life we have discussed. Initially, they are called as before incorporation, subscribers to memorandum. After incorporation, they are called as shareholder. But once a company goes into liquidation, they are called as contributors. They'll contribute to the assets or liabilities. That will help them pay off the liabilities, settle the liabilities. Let's start with section number 3 first and foremost. Section again. We are entering into that part of the chapter 2 of Companies Act, called as incorporation, which is ranging from section numbers 3 to 22. What chapter? Chapter 2. Don't find it in material, you will not find it. ICMA has combined your chapter 1, chapter 2, chapter 22 and some parts of LLP topic combined into one chapter. But technically we are entering into which chapter? Chapter 2, incorporation, section numbers 3 to 22. Let's start with section number 3, talks about formation of company. What is section 3? Otherwise, give me the section numbers we have learned until this point of time. Section number 268. Materials closed. Books materials closed fast. Good morning. Had lunch? Hefty lunch? Good morning. 268, 271, 285. Some company, sir. 220, 220, 242. Okay, you answer the word company, I'll answer the rest of it. Subsidiary company. 287. 87. Associate company. 2 clause 6. Clause or subsection? Clause. They are not related to each other. We use the word clause. Government company. 245. Private and public were done right. Private is 268. Public is 271. Company is 220. Foreign company. Subsidiary company. 287. Listed company. 252 and foreign company 20 off 242 and small company is important, amendment happened 285. Is it fine? Now we are entering into the second category. Let's start with section number 3 called as what? Formation of company. Let's form a company. To form a company, they have given the basic introduction. A company may be formed for a lawful purpose. Company may be formed for a lawful purpose. That means we can also incorporate a company for. The words are very clear. Company may be formed for a. That means you can also form a company for unlawful purpose. Which is better, CMA or unlawful? We'll start kidnapping from tomorrow. Today it's. Why to waste time? We'll start it today. The words are still correct. Company may be formed for lawful purpose, but again, companies act as a fool or you are fools? Both. Companies act has made a mistake in this logic. They should have drafted what wordings? Company must be formed for a lawful purpose, but what are the wordings drafted by the lawmaker? They've used the word company may be formed. But we'll write still as may be formed, we'll read and understand it as what? Company must. Can we start illegal businesses? Can we start kidnapping from tomorrow morning? We'll be very professional with it. We'll start a company for kidnapping. Can we start? Yes? Excellent. Company maybe or must be? Maybe. It is used as maybe, but we'll read it as what? Remember the same logic we have done in foreign company topic also. What word should have been used? What word has been used? We'll read it as, but we'll write it as here. Company. We'll write it as what? Maybe, but we'll read and understand it as company must be. So company may be formed. Company may be formed for a lawful purpose. That means company can also be formed for. No, it must be formed for lawful purpose. We have two categories of companies as usual, private and public. To start a private company, to form a private company, we must have at least 2 shareholders. How many? 2 shareholders. 2 or more persons shall be existing to start a private company. Similarly, for public company, how many? 7 or more. 2 or more for which company? Private company. For a public company, we'll have 7 or more, and we have a special kind of company here, OPC. For OPC, we'll have how many? 1 or more. One person company concept itself is that they're encouraging a sole proprietor to come into company form on business. They'll have how many members? 1. 1 person. Start the logic here. If you want to have 2 shareholders, we have done the share contract already. Who is selling the share? We have done this. Who is selling the share? Okay, I want a technical word itself here. There are 2 ways in which shares can be sold. It can be sold by the company first. When the company creates it and sells it, we use the word company allots it. And from your side, I call it as you have subscribed it. This word subscribe and this word allot can be used only when it is coming from the company itself. Once you have purchased it, can you transfer the shares? Are you free to transfer them? Once you have transferred them, they're not called as sold. They're not called as sold. They're not called as allotted. They're not called as subscribed. They're called as transferred. So give me the technical word. If I use the word allot, who is selling it? Company. If I use the word subscribe, who is selling it? Company. If I use the word transfer, is company selling it? No. Are we talking about new shares or existing shares? Existing shares are transferred from an existing shareholder to another investor. Does the share capital increase? Does the share capital increase? Number of shares increase? No. It remains the same, but company will have a different shareholder, different investor. That is a word where what we use is transfer. If we use the word allot, who allots it? Company. If I use the word subscribe, it is referring back to the topic of purchase, but subscribe from whom? Company. Can I use the word subscribe in the stock exchange? Can I go purchase shares in the stock exchange today? But will I be calling myself as subscribed? No. I'll call it as what? Transferred. I'll be a transferor or transferee? Transferee. I'll purchase it. So give me the wordings here. For a private company, you must have how many shareholders? 2. Who will sell the shares? Who will allot the shares? Company. Company will allot shares to a shareholder, but the company to allot, the company must exist first. For the company to exist, we have to submit documents to the ROC. To submit documents to ROC, we must have shareholder. Possible? It is not possible to have shareholders even before the company is incorporated. Point is, you sell the shares to them, you allot the shares to them. If they're holding the shares, they're calling themselves as shareholder. That is practically possible after incorporation or before incorporation. But for the company to be incorporated as an artificial person, we have to incorporate it. We have to register it with the ROC, we have to submit documents. Who will submit documents? Can the shareholder submit documents? That's the reason they have brought in a new concept called as subscriber to memorandum. What do you mean by subscriber? A person who has agreed and signed. Signed what document? Memorandum of association. I hope you are comfortable with this memorandum words, etc. So I'm directly jump into the concepts. What do you mean by subscriber to memorandum? Give the meaning behind it. A person who is signing. Signing which document? Memorandum of association. He has not become a shareholder, but he has promised to purchase shares. When will he be able to purchase shares? After incorporation. Today, can I call him a shareholder? Tomorrow, when the shares have been allotted to him, will he become a shareholder? But today, I am calling him as a subscriber. Subscriber to which document? Memorandum. Purchased or promised? Promised to purchase. When did he give the promise? Before incorporation. When will he fulfill that promise? After incorporation, he'll become a shareholder. After the company got incorporated, 5 years later, company is again selling shares. Can I subscribe the shares from company? Will I become a subscriber or shareholder? I'll be directly called as a shareholder. The person who was at the beginning will be initially called as subscriber, later converted into shareholder. Or you can directly become a shareholder after company is incorporated. So what's going to happen? If the company wants 2 shareholders, indirectly company should have how many subscribers? Those 2 subscribers will get converted into shareholders. To start a private company, I should have how many subscribers? Public company? Is it fine, comfortable as of now? Can I have 5 subscribers for a private company? Yes. This is 5 subscribers before incorporation or after incorporation? Before. Once the company will do the incorporation registration process in a bit. Once the company has been incorporated, these subscribers will be given shares. I'll not use the word given. They will be allotted. Once the shares have been allotted, they'll become shareholders. How many shareholders will I have? Is it fulfilling private company topic? A private company must have how many? 2 or more. To have 2 or more, indirectly I should have how many subscribers? 2 or more. For a public company, I must have how many subscribers? 7 or more. For an OPC, how many subscribers? 1. Continue that. That's your section 3 done, Amma. We have an amendment in this. Start answering this. 5 subscribers to memorandum. Say assuming I'm a public company. Which company? Public company must have how many members? 7 or more. What's the minimum? 7. What's the maximum? Unlimited. Remember this number of directors topic we have done? Section number 149, subsection 1. We'll always have this ascending order: OPC, private, public. Number of directors, 1, 2, 3, maximum. Can we appoint 15 for all of them? Can we appoint more than 15? Decide one answer. No, but there is an. With the prior approval of shareholders by passing a. But the special resolution is not required if you are a government company or section 8 company. Don't stop there, continue that. Which is not defaulted under section number 137 and 92. This was number of directors under section number 149 subsection 1. Similarly, we also have number of members through section 3. We know these numbers already. For an OPC, minimum, maximum. Private company, minimum, maximum. We have seen this 200 in the restrictive clauses. Then for a public company, minimum 7, maximum. So assume that we are a public company. How many? We are a public company and we are having 7 members. Is it allowed? Yes. We have 7 members. Say we have 7 members in the public company. Out of the 7 members we have, one of the member Ekant died. 2 minutes of silence. After that, forget about Ekant. What is more important for us? Ekant or company? If Ekant dies, let him die. We have the concept separate legal entity, perpetual succession. If he dies, does it affect the company? Who will continue the process? Legal representative. His shares will be succeeded. Succession will happen and securities will be transferred to his legal representative. But the main problem arises if the company, if Akan doesn't have a legal representative. If he has a legal representative, there's no issue. How does the legal representative concept arise? I hope you guys remember this. Whenever a member dies, his securities will be transferred to his legal representative, but we don't use the word transfer. We have a concept called as transmission, if you remember. We have to go intimate the company that Akan died. How would company know he died? Company will have lakhs of members. Members may die on a daily basis. Company doesn't care. We have to go intimate to the company stating that Akan has died. I am his legal representative. Please do transfer those shares in my name. This is what should happen, and it should be informed to the company. Once it is informed to the company, then the company will remove whose name? Akan, and enter whose name? Legal representative, then he'll become the shareholder. Now just imagine this. If Akan died and he doesn't have a legal representative at all. Nominee topic has not yet arisen. We'll use nominee in OPC topic. As of now, forget nominee. Okay. We have how many members? We are which company? It should have how many members? 7 is minimum requirement or maximum requirement? And the company had 7 members, but unfortunately, Akan, one member, died. If he dies, do we care? Yes, we care. Not because of Akan, but because of the number of members. The public company shall have a bare minimum of 7, but because of his death, now the public company has only 6 members. With 6 members, can I call you as a public company? No. That means you have to appoint another member to carry on the business as a public company. To call yourself as public company, you must have a bare minimum of 7, but for whatever reason that might be, your number of members have fallen below the minimum requirement. What is the minimum requirement? But your number of members have fallen below minimum requirement of 7. Now you only have how many members? 6. Can you call yourself as public company? No. You cannot call yourself as public company with only 6 members. What shall be done? You have to increase the number of members too. And the Companies Act states that it is not practically possible for you to increase the number of members immediately. You have to find a person who has the same ideology. You have to find a person who is ready to bring in finances. It will take time for you to find a member. Are we crying? You should say yes, some Akan died. Are we crying? Are we sad? At least keep sad faces, don't smile. Ekant, look at you. I can look at all of them. They're smiling if you're dead. Ekant is dead. You are sad. Are we crying? We are at the funeral of Ekant. And what are we thinking? To appoint a new member? No. We will not appoint a new member immediately after his vacancy. It will take time for you to find a person. Companies Act states that I'll give you a time of 6 months to go appoint a new person. How many months? In this 6 months, even though you have less than 7 members, I'll still assume you as a public company. Are you getting the logic clear? You're not a public company technically. To be called as public company, you must have at least 7, but you're not technically a public company, but I'll assume you as a public company. I'll give you time to increase the number of members to meet the minimum requirement again. How many months have I given you? 6 months. In this 6 months, what is your duty as a company? Appoint. Allot securities to another person and be making member and reach the 7 minimum requirement. Is it fine? Start answering with multiple examples here. How much time is given to you? 6 months. Now, after say 2 months, you have increased the number of members to 7 again. You fulfill the requirement. How many members should have been there? 7. For uncertain reason, it fell below 7. Companies had accepted the situation and stated, I'll give you time. How much time? 6 months. You have taken 2 months to increase the number of members. Start answering this clear, Amma. In this 2 months, technically, are you a public company? Yes or no? No, you are assumed. Conceptually speaking, number based speaking, you are not a public company at all, but you are assumed. Assumed for how many months? 6 months. But here you have filled it within 2 months. In this 2 months, are you public company or deemed to be public company? Good. This period, are you a public company? Because you have fulfilled the minimum requirement, you are actually a public company. Is it fine? Next case, same situation. Number of members have fallen below the minimum requirement. Companies Act has given you a time limit of 6 months. You have increased the number of members. Can you increase number of members here in the 6th month? It is still complying with the provision. If you have increased it, say assuming in the 5th month, give me the answer. For these 5 months, are you a public company or deemed to be public company? If it is deemed to public company, I want a little more detailed answer. You can still do business. You can still go enter into contracts. Give me the answer. Contract is entered with a third party. Contract is entered by whom? Company, because you are still deemed to be a company. The contract is entered by the company with a third party. Now this last 1 month we have here. You are deemed or actually public company? Last question. Give me the wordings. The number of members have fallen below. Concept, fallen below minimum requirement. Companies Act gives you a time limit of in which you have to increase the number of members to the minimum requirement. In this 6 months, you are technically not a public company, but I'll assume you to be a public company. I'll deem you to be a public company. Now comes the problem. We did not increase the number of members even after 6 months. 6 months have elapsed. You have not increased the number of members to 7, the minimum requirement. Start answering it to the question specifically asked. In the 6 months, are you a public company? Deemed to be a public company. Who gave you this assumption? Companies Act. How many months did you get? In the 6 months, if you are still carrying on your business activities, you might have still entered into contracts. And the contract is entered by the company with a third party. Now, after the 6 months have been elapsed, that assumption no more exists. The assumption of being a public company was given only for 6 months. After the 6 months, do we have this assumption existing? If that assumption is not existing and you still enter into contract with a third party, think an answer, ma. Who is entering into contract? Is it 6 people entering into contract or the company? 6 people. We don't have this assumption to be called as public company anymore. How many people are entering into contract? 6 of them entering into contract with whom? Third party. If 6 of them are entering into contract with third party and we don't call it as a company, there's no separate legal entity. Contracts entered after 6 months. Who is liable? Limited liable? No. There's no separate legal entity. There's no corporate will protecting them anymore. After 6 months, contracts are assumed to be entered by the members themselves personally. Hence, their liability will be limited or unlimited. They'll be personally liable for all the transactions that will arise after 6 months. But what about this 6 months? Give me the logic behind it. In this 6 months, are they technically a public company? No, but I have given you assumption. I've given you the privilege to be still called as a public company. Even though there are only 6 members existing in your company, it is still assumed that the contract was entered by company. If the contract is entered by the company, who is held liable? Company itself. Acts done by the company. Company itself is liable. Are you getting the logic behind it? For the first 6 months, who is liable? Company. After 6 months, whatever contracts are entered, who is liable? Members. Members will be personally liable because these members have failed to increase the number of members to minimum requirement. There's a new addition happened under section number 3A. What is 3A? Whenever a new section is added and they don't have space to add it, they'll squeeze it in as capital A. We have discussed this already, Amma. How many sections are there? 470. These 470 sections have been divided into multiple chapters so that it will be easy for you to group all the relevant sections together. Each category was called as what? A chapter. Now what happened when 2013 Act came into existence, this logic of 6 months was not existing. They wanted to add it later. If they wanted to add it later, will they add it as section 471? If it is added as 471, it will not be linking with incorporation chapter. So they wanted to add it in incorporation chapter, but all the section numbers have already been taken up by some other provision. They had to add, but they don't have space to add it. Then they'll create a New section. They'll create space. Where? Section number 3A. Whenever capital A comes in, it's a section which is added when? In 2013 or after 2013? After 2013, to make space in that particular chapter, they'll create capital A. We have seen this 76A in deposits, remember? 76A is again a new section that is added, penalty section for deposits chapter. We'll learn it. We'll have 3 to 4 sections which are added in such manner. We'll learn them. What is this? Section number 3A. Section number 3A talks about liability of members in certain cases. Their liability here is limited or unlimited. After expiry of how many months? For the 6 months, their liability is, because contracts are entered in the name of. After 6 months, the assumption of being companies not existing, contracts are entered in the name of members, and the members' liability will be limited or unlimited. 90% concept is done. A small explanation is given on this. We have how many members in total? 7, out of which who died? Do we care? But we have to increase the number of members too within 6 months. Whose responsibility to do it? Rest of the members? What do you mean by company? Who will allot securities? Who will take the decision to allot securities? End of the day, again, decision taken by shareholders. That means the existing shareholders have to take this decision. Start answering it. Think about it. We have 8 members in the company. How many? 8 members. And Ekant died. Start. We have 8 members. Ekant died. Do we care? Will we apply this minimum requirement? No. We are still fulfilling the minimum requirement. What is the minimum requirement? 7. We had 8. One of them died. Do we care? If at all, at any point of time, number of members have fallen below minimum requirement of 7. That's where this logic comes in. Say we had only 7 members and 2 of them died. Same logics? Modified answers. You guys draft it now. A public company must have bare minimum of. But if at all, at any point of time, the number of members in a which company? Public company have fallen below minimum requirement. Don't use the word 7 amount. Minimum requirement. Then the company has a time limit of 6 months to add number of members and to meet the minimum requirement. In this 6 months, it will be deemed to be a public company. If it fails to appoint number of members and meet minimum requirement within 6 months, after expiry of, all contracts entered by the company will be assumed to be entered by members, the existing members of the company. In this case, how many? 5. Then who will be held liable? 5. Personally liable? Limited or unlimited liability? Last question. We have 7 members. Ekant, one of the member died. We have to increase the number of members. Who should increase the number of members? Rest of the existing shareholders. But out of the rest of existing shareholders, what happened is, one of the shareholder was located in the US. Where was he located? He was not in India. He was not having knowledge of what's happening in India. There was no communication between them. Now think it from his perspective and start answering it, Amma. You are one of the shareholder who is located outside India, who did not have knowledge that Ekant in India had died. You did not have knowledge that the number of members have fallen below 7. If you don't even know that the problem was existing, can I blame you for not creating solution for it? Are you getting the point clear? You didn't even know that number of members have fallen below minimum requirement. I cannot come and blame you for something which you have not even known for. Start the answers. If the number of members have not been increased within 6 months, all 6 of them will be held liable. Who will be held liable? Why? Only those members who had cognizance about it, who had known about it, who were aware of it. Out of the 6, how many of them were aware of it? 5. Only these 5 people will be held personally liable for the transaction that happened after 6 months. The person who did not have knowledge, but whether you had knowledge or not had knowledge, prove it in the court of law. If you are able to prove that you did not have knowledge about it, you are liable or not liable? Not liable. Who will be held liable? Only such member who had cognate about it. What do you mean by cognate? He was aware that the number of members have fallen below the minimum requirement of 7. Same logic applied for private company. Private company must have how many members? Minimum 2. Can it have more than 2? A private company had 5 members. One of the member died. Does it matter? Private company had 2 members. One of the member died. Same wording, same logics. We have to increase the number of members to minimum requirement. But this time, what is the minimum requirement? 2. Within how many months? In this 6 months, you are still deemed to be a private company. In this 6 months, if a contract is entered, it is entered in whose name? Company's name. Hence, the member's liability is limited. But after 6 months, if the number is not increased to minimum requirement, contract is entered in whose name? Only one member is left. One member's name or the company's name? Member. His liability will be limited or unlimited? Unlimited. Same logics will apply for private company. And last category, OPC. OPC must have how many members? 1. You should be able to answer this. You know these logics. If that one member dies, we have to increase the number of members. You already have a backup ready. You already have a backup ready called as nominee. This situation will never arise in OPC. The situation of fallen below minimum requirement will arise only in case of public company or a private company, but will never arise in case of OPC because we already have a backup ready. Who is this? Why nominee will come to that in a bit, but is this fine, Amma? This is section number 3 and 3A. Basics are done. Let's incorporate the company now. Section number 7 talks about incorporation of company. What is it? Section number? What is section 3? Formation of company. I have discussed about the basics of company. Then we'll start section 7 now. What is section 7? Incorporation of company. What happens in this? Incorporation of company, we have discussed this in the first class already. Incorporation and registration, which is a wider term. What do you mean by registration? You have to submit documents to the ROC. Once you have submitted documents to ROC, ROC will register you as a company. Once registered, are you incorporated? Once registered, will you come into existence? What is incorporation? Bringing the company into life is called as. One of the ways in which you can incorporate is registration. But you also have second option where we call them as which company? Statutory company. It is incorporated. Incorporated or registered? Incorporated by a special act of a parliament. But here section 7 will be focusing on which type of company? Registered. Even though the heading is called as incorporation of company, technically we are doing what? Registration of company. We have to submit documents to the ROC. Try to understand it. End of the day, company is a separate legal entity. Company is a separate legal entity. Company has every single right you have as an individual. You have certain rights. Yes. You have certain rights. You have certain basic fundamental rights as a citizen of India. Companies Act states that company is also a separate person. It will also have certain rights in India. Companies, if it is treated as a person, try to understand it. The company can do legal activities. There's a chance that company might also do. But company doesn't have its own brain. Company doesn't have its own brain. I'll be a little quick on this topic. You are aware of these logics. What will happen? The brain of the company is nothing but your memorandum and articles of association. Company is an artificial person or natural person? Does it have emotions? Does it have thought processes? The thought process of the company is drafted in a book called as Memorandum and Articles of Association. These are the 2 books by which the company is governed. These 2 books are drafted by subscribers to Memorandum. So what's going to happen here? If you are given an option to incorporate company on your own without it being verified correctly, there's a chance that you'll create a company for illegal purpose. And the company doesn't even know what is right, what is wrong. It doesn't have thought process. It doesn't have its own brain. Its brain is nothing but a book, MOA and. If the book states that kidnap people, company is happy to kidnap people. Company doesn't understand what is right, what is wrong. So can I say these documents have to be carefully drafted? Once they are drafted, we also have to verify them before we create this company. That's where the bridging gap starts. These documents have to be submitted to an authority called as ROC. Once the documents have been submitted to ROC, ROC will not blindly incorporate you as a company. They'll verify. Once they are verified, if they are satisfied that the documents are correctly drafted, then they'll allow you to get incorporated. So who incorporates the company end of the day? ROC. But with the documents you have submitted, I'll verify them. If I don't verify, I don't act as a bridge here, there's a chance that you might incorporate a company for illegal activities with wrongful information. So what will be the flow of process? If you want to incorporate a company, you go submit documents to explain who you are as a company, create documents called as memorandum and articles, let the ROC verify. After ROC has verified, if ROC is satisfied with them, ROC will incorporate you as a company. When does a company come into existence? After incorporation or before incorporation? But this document is drafted at what point of time? Before incorporation. Now look at it. Harsha, he has done a good amount of fraudulent activities in the past. What do you mean by fraud? Intentional or unintentional? Harsha he has done fraudulent activities. Harsha is a fraud. If he starts a business, the business will also be. There's a chance that the business might be fraudulent in nature. Think about it. If this guy drafts this document, memorandum of association, articles of association, there's a chance that he is drafting the brain of the company in an illegal manner. Brain of the company is nothing but the brain of the person who drafted MOA and AOA. Who will draft this MOA and AOA? Subscribers to memorandum and anybody incorporate a company. You have done a fraud. Can you incorporate a company? Why? What was the logic behind it? If you have done a fraud and you're creating a company, you'll create a company also in that illicit mindset, a wrongful mindset. There's a chance that company might also be doing wrongful activities in the future. I don't even want you to incorporate a company. So who will verify all this? ROC. ROC will verify everything. If ROC is fully satisfied, then they'll incorporate you as a company. So ROC. What is ROC? Let's talk about the authorities a bit. Companies Act is governed by one particular authority in India, one Ministry of India called as MCA. What is it? Ministry of Corporate Affairs. Don't judge it, this is India. MCA. For the entire corporate structure in India, who will regulate it, who will administer it? MCA, Ministry of Corporate Affairs. Obviously, every single government body, government department has its head office in New Delhi. MCA also has its office in New Delhi. Can they manage entire India on their own, sitting in New Delhi alone? Hence, MCA has divided India into multiple regions. They have divided India into a total of 7 different regions, and for each region, they have appointed a head. Regional director. As a whole, India has one authority. What's the only one authority we have? MCA. But MCA, for the purpose of administering entire company law in India, they cannot do it alone sitting in New Delhi. They decided to divide India into 7 regions. Each of the region has been appointed with a person called as regional director. So what happened? We have 7 regions in total. You don't have to remember it. You can forget it afterwards. Remember that there's 7 RDs. What are the 7 regions we have? Southern region, northern region, eastern, western, central. 5 regions are done. Then we have special importance given to Telangana and Andhra Pradesh. Telangana and Andhra Pradesh are called as southeastern region. You have a special region given for Telangana. Again, more businesses are there in Telangana, hence they have been drafted as a separate region. Then the northwestern region is given a separate importance. Gujarat, Maharashtra, they are given a separate importance here. In total, how many regions are there? 7 regions. Each region has been appointed with a person called as regional director. Region, now we have divided India, a very vast country, into 7 parts. Each part is appointed with one person called as regional director. Can he manage entire region on his own? No. Then the regional director, the region was subdivided into again small parts, each part called as jurisdiction. What is it called? For each jurisdiction, we have appointed a person called as registrar. Get the word clear? It is not ROCMA, it is registrar. What is it? Registrar. We have a total of 25 registrars in India. These registrars will maintain books relating to whatever companies that are incorporated in their particular jurisdiction. They are called as what? Registrars. The book which have been maintained will contain the particulars of all companies which are incorporated in their particular jurisdiction. If a company is getting incorporated in a jurisdiction, they have to go approach the registrar, submit documents, and get the company incorporated. So this book maintained is called as, that's where the name comes from. The book maintained is called as, it's a register end of the day. Register of what? Companies. That's where the word comes, ROC. Register of companies. Simply speaking, it is a register which is used to maintain companies' details in it, but it is long outdated. Do we maintain physical books now? But it is still called as what? Register of companies. So this registrar is sometimes misinterpreted by Companies Act as ROC. Who will maintain this book? Who has the responsibility to maintain this book? Registrar. Original topic is he should be called as registrar. What is his responsibility is to maintain a book called as Register of Companies. Sometimes the Companies Act will use the word Register of Companies in place of registrar. Actually speaking, there are two separate wordings. What should have been the original word they should use? Registrar. But sometimes they use the word ROC. They are using this word ROC. But there are still mistakes in it. Come to it. How many MCAs are there in India? 1. This MCA has divided India into how many regions? And we have how many regional directors? 7. Under regional director, each region has been again subdivided into multiple jurisdictions. Jurisdiction is an area over which an authority has a power. Each jurisdiction has been appointed with a head called as registrar. How many registrars are there in total? 25. We have a total of 25 ROCs in India. How many MCS? 1. How many RDs? How many ROCs? 25. These 25 ROCs. So we have to go submit documents. Now we have to go submit documents to whom? As a company, you will be regularly connected with whom? MCA? No. RD? No. You will be regularly connected with whom? ROC, the registrar. You have to go submit documents to the ROC, but this is also outdated now. You don't submit documents to ROC. If you submit documents to ROC, just imagine this. Can I incorporate the company with the name Reliance? Yes or no? Why? But ROC of Telangana might not know it. Reliance is a very famous name, forget about it. We have 17 lakh companies active in India, 27 lakh companies which are registered in India. Will the ROC of Telangana know every name of every company in India? If you are maintaining documents for each jurisdiction separately, it will be difficult for me to track it. Then the Companies Act has recently brought in a new concept called as we'll have central registrations. We'll not have registration for each state, each jurisdiction separately. Registration process will now happen at a central level, a concept called as CRC, Central Registration Center. CRC has been established not for every replacement of ROC. Are you getting the point? Only for incorporation of company, the ROC's work have been diverted to CRC. For incorporation, I'll submit documents to ROC or CRC. Then after incorporation, I'll have to submit more information with ROC. I have to file financial statements. I'll file financial statements with whom? ROC. ROC still has importance, don't completely remove it. ROC's power to incorporate company have been diverted to CRC, which happens at a centralized basis, which is located in Gurugram, Haryana. An office called as Central Registration Center. What is it? CRC, Central Registration Center. Back in the day, documents were supposed to be submitted to whom? ROC. Now amended. It is going to be submitted to the CRC. Start the process. Authorities are fine, right? Also give a clarity on the judicial part of India, judicial part of Companies Act, judicial bodies. Be a little quick. This will be useful for understanding the law. If you have any dispute, you'll go to a court. Court cases in India are long pending. Thanks to our population, we have this many of disputes which are pending because the amount of population is large in number. Number of courts are not having sufficient time to cater it. There are situations where the first hearing, forget about the order being passed, the first hearing came after 5 years, 6 years. You file a suit today, the hearing, the first time the court hears your case after 5-6 years. Imagine how many years afterwards they'll pass an order. You'll even forget the case. There are situations. I've practically seen one of my friend working on a case which was filed 10 years back. Documents are all lost. They're creating documents again to file the case. Literally, they're creating documents to fight the case now. 10 years back, they filed a suit and the hearing came now. Will they remember anything? Do they have documents? No, they don't even have documents. They had to create documents now to fight the case. But understand it, the judicial system is so lagging behind in India. If a company also goes and stands in this line of judicial system and waits for a number of years for the decision to be taken, business will be stalled. There will be a delay in the business activities. To make sure that this court procedures are done as expeditiously, as fast as possible, we just imagine this, this is a court we have, and there are people who are standing one after the other for their case to be heard and order being passed. Now Companies Act states that you don't stand in this regular line of the court. We'll have a separate line created for you. We'll have a separate court established for you. NCLT. National Company Law Tribunal. A special court being established. Special courts are there for every act. Money Laundering Act, we have a special court. Securities law, we have something called as SAT, Securities Appellate Tribunal. A separate court is established. For competition law, we have a separate court. For Companies Act, we have a separate court called as NCLT. What is NCLT? National Company Law Tribunal. What is National Company Law Tribunal? If you have any dispute under Companies Act, you will not go to your High Court, Supreme Court. You will not go to your District Court, Magistrate Courts. You will directly go to the NCLT. NCLT will deal with only matters relating to Companies Act. If it is dealing with only Companies Act, it will have less cases. They'll have focused discussion. Orders will be passed a lot more faster than compared to the normal court. This has been drafted NCLT. But if you're not satisfied with the order passed by NCLT, you can go appeal it. Usual what process? Go to District Court. If not satisfied, you will go to the High Court. Then if not satisfied, go to the Supreme Court. Same process. If you're not satisfied with NCLT, you can go to a higher court called as NCLAT. National Company Law Appellate Tribunal. First point you'll go to. Give me a understanding on this. If you have a dispute in company law, can you go to District Court? They'll not accept your case. If it is relating to companies, who will accept your case? Only the NCLT. If you have any other dispute other than Companies Act, can you go to NCLT? No. They'll not accept your case. NCLT will accept only cases relating to companies. That's an exclusive court established, NCLT. If you're not satisfied with the order passed by NCLT, you can make an appeal to the NCLAT. What is NCLAT? National Company Law Appellate Tribunal. Until now is fine. If you're not satisfied with NCLAT also, you can directly go to the Supreme Court. No High Court process. NCLT. If not satisfied, NCLAT. If not satisfied, go to the. You're not satisfied with the Supreme Court's order as well. Go home and cry. That's the apex body we have. If Supreme Court not satisfied, go home and cry. Can you appeal it? No. First option. Then LAT. Then NCLT will deal with matters relating to only companies. Only relating to companies will it deal it. Okay. Now come back to the registration process section number 7. How to incorporate a company? Who will incorporate a company? Subscribers to memorandum. You know this logic, so I'll be very quick on it. Who is submitting documents? Subscribers to memorandum. With the amendment, give me the answer. Subscriber to memorandum are submitting documents to the, not ROCMA, submitting documents to CRC. CRC, which is now centralized or jurisdictional based? Centralized. Everything happens in one office today. So they'll submit documents. Subscribers to memorandum will submit documents to the CRC. They'll submit what document? The first document required to be submitted is memorandum and articles. The memorandum and articles is required to be submitted to CRC. Will the CRC verify? Yes. After verification of these two documents, then the CRC will give you approval or rejection. If they're accepting it, they'll incorporate you as a company. But try to understand it. The MO and AOA are drafted at what point of time? I'll use these words near future, maybe tomorrow or day after tomorrow. MO and AOA are drafted at what point of time? before incorporation. Drafted by whom? Subscribers to memorandum. Companies incorporated, not incorporated. Not incorporated. These documents will be verified by whom? CRC. But the documents, if they have not been correctly verified, there's a chance that they'll incorporate a wrongful company. Whose responsibility now? CRC. Now imagine you as CRC. The MOA and AOA documents will be somewhere around 200 to 500 pages depending upon the company. Subscribers to memorandum came to you, threw the book on you, go read it. Now you have to read the entire memorandum, read the entire articles, compare with your Companies Act, check whether everything is in line or not, then you incorporate a company. It'll take time. It'll take how much time? If you have been given 200 pages of book, how much time will you take to read it? At least 1 year. And don't get this assumption, every company which is every entity which is wanting to be incorporated as company in India will come to your office. There will be hundreds of applications made every day. How many years will it take for you to read the entire documents of all 100 companies and incorporate the company? So what happened? You made an application today for incorporation of company to the CRC. The CRC after 2 years comes to you, states that finally your company has been. Who are you? Which company? What company? When did I submit documents? I don't even remember after 2 years what company am I talking about. After 2 years, the business opportunity has already gone past. Is there any reason of incorporating company? Is there any meaning of incorporating company after 2-3 years? No. The companies had wanted this to happen as quick as possible. For this to happen as quick as possible, can the CRC sit down to read every letter of this 200 pages? That's where they started adding this logic. Will not verify it on a conclusive basis. I'll not verify each and every word of it. I'll verify it on a prima facie basis. I'll verify it, but verify it only on a prima facie. Are you guys getting, you know the difference, right? Prima facie, conclusive. Conclusive, I'll go in depth to the document and I'll understand the objective behind it. Prima facie, I'll just look on the face of the document and say it is right or wrong. A classic example for always this is your balance sheet if tallies. Prima facie. On the face it looks good, but we know how adjustments we have made to tally it. That's your conclusive evidence. If you have understood it in detail, then it is called as conclusive. But on the face, as soon as I look at, I'll assume that it was correct by concept of prima facie evidence. Now ROC stated that I don't have enough time to do conclusive evidences. I'll just check the documents, verify it, but only on a prima facie basis. That's where the problem starts. If the CRC is verifying it only on there's a chance that the document has a misstatement, but the misstatement could not be found out. There's a chance that it has a misstatement, but CRC could not find it out because he was doing only a prima facie evidence. Then the CRC states that I want a promise made from your side. Make a promise that the documents submitted are correct. Make a promise that you have complied with all the provisions of Companies Act. I cannot sit down and check everything. Make a promise. That layman language promise is technically called as a giver declaration. Why is a declaration required? Because I am not able to verify it completely. I want you to come and make a promise. If you break the promise, I'll come break you after the company is incorporated. I'll punish you. Are you getting the logic? You give me a promise, you give me what? A declaration. Declaration stating that the documents are correctly prepared. Declaration stating that these documents are complying with my Companies Act. You check it correctly and submit it to me. I'll shift the burden of verification not from me, CRC, to the subscribers. You guys check it and give it to me. You check it and give it to me. You make a promise. You are making what? Promise is a layman language. We use the word declaration. We are making declaration about two things. Make this very clear. Declaration that your MOA and AOA are correctly submitted. Declaration that your Companies Act have been complied with. You have followed the entire Companies Act. What are the two declarations that's happening? Where are we? Section number. Are we comfortable? Am I going fast? This is all known, right? But I want logics behind the words also understood. Comfortable, right? Who is submitting documents first? submitting it to the CRC. What is CRC? Central Registration Center. Are the ROCs still existing? But they'll take care of everything other than registration, incorporation process. Other than registration, everything will be taken care by ROC itself. Now come back. We are submitting. The first document we submitted was MOA and A. Nothing but the brain of the company. Who wants to verify this? But can they do conclusive verification? They'll do only a. Because they're doing prima facie, can there be a chance that they might overlook a misstatement? Hence, I want you to submit a declaration. Declaration regarding two things, stating that the document is correct and you have complied with Companies Act. Complied with Companies Act. Try to understand this word before we move forward. Complied with Companies Act. Companies Act has how many sections? You are a cost accountant, yes? You are a cost accountant. Do you have knowledge of Companies Act? At least by the time you become cost accountant, will you have knowledge of Companies Act? You know how to incorporate company? You know how to submit documents? You know how to communicate with CRC or ROC? You go to a businessman and start explaining everything to him. Sit him down. Start explaining Companies Act, section number 7, sir. He'll find another cost accountant. Are you getting the logic? You're not going to explain him to him. You're not going to make him sit and teach the Companies Act. The responsibility of complying, I'll not take it as a businessman. Why did I appoint you? So that you'll comply with all rules and regulations on behalf of me? I had to comply because I don't have knowledge on it. I'll appoint you the professionals. You the experts will be appointed for the purpose of fulfilling the compliance requirements on behalf of a businessman. Now, if this is the situation, try to answer this. If you have been appointed, a cost accountant have been appointed to help the businessman incorporate a company, will I read the Companies Act? Yes or no? Will I understand Companies Act? Will I comply with the rules and regulations? Am I required to comply? Yes. I'll put the burden on whom? You, the cost accountant. Now, who has to comply it on behalf of me? The cost accountant. If the cost accountant does not comply with the rules and regulations of Companies Act, answer to the question asked, just try imagining the situation. If the cost accountant does not comply with the rules and regulations of Companies Act for incorporation purposes, can the authorities come and blame me? Have I done wrong? Who should they blame? Cost accountants? Then Companies Act states that we'll have two declarations separately filed. Declaration regarding compliances, I will not give it. I'm not declaring that compliances were done correctly. I never knew about compliances. We'll give declaration for compliances. Experts. But these documents, I prepared it. I'll give declaration regarding the documents prepared. Are we getting the topic clear, Amma? You're going to submit how many declarations? 2. What are 2 separate declarations filed? Declaration stating that the documents are correct. Who will give that? Subscribers. Documents, I have drafted it. But who will comply with the rules and regulations? Experts. Let them give the declaration separately. I'll just frame the sentence. I hope you guys will understand the concept behind it now. A declaration by the CA, CMA, CS or an advocate or the director, first director, manager or secretary of the company stating that they have complied with all the requirements of Companies Act for incorporation of a company. Declaration was given by experts, the group of people who are responsible to incorporate companies, stating that all the requirements of Companies Act for incorporation have been complied. They have given declaration that compliance is done correctly. Subscriber. Am I responsible for compliances? No. I'm responsible for what? Compliances or this document? Document. Second declaration is given by whom this time now? Subscribers to memorandum. Stating about these documents. Stating that the documents submitted are true and correct. All correct documents have been submitted to you. I'll promise for which part? Compliances or documents? Are we comfortable with this, Amma? Compliances, who promised it? Experts. Documents, who is promising it? Subscribers. What document have to be prepared? But MO and AOA, do I understand how to prepare them? I'll take help of them again. Whose help? I'll take the help of a director. Help of whom? That's where again a small problem arises here. It's all interlinked with everything. Director. We have done this already. Company gets its finance from whom? Shareholder. But skill from the director. We'll have one director or more than one. All of them combined together will be called as board of directors. Powers are in the hands of director. Powers in the hands of board of directors. Board of directors are appointed by the company with the help. Is the company incorporated? What do you mean by directors now? A person who has same topic, a person who has promised to become a director when the company is incorporated. Today he'll be called as subscriber to director. No. He'll be called as first director. What's he called? First director is not appointed. He's promising to act as director, but when company is incorporated, he's helping the company's formation process. He's called as which director? First director. How would he become director? Simply mention his name in the articles of association, he'll become a director. How would I become a first director? By mentioning my name in the AOA. I'll become a first director. Subsequent director, the second, third, fourth, subsequent directors are appointed by the company with the help of the shareholder. First director is not appointed at all. He's gonna directly act as director if his name is mentioned in the AOA. He's called as which director? First director. The subscribers to memorandum will take the help of the first director and prepare these documents MOA and AOA. I want these persons to be very pure. As we were discussing about it, Harsha, if he's a fraud, can he act as a subscriber? No. Can he act as a first director? No. Think carefully and answer. Why did we say no to this? If Harsha drafts the document MOA, that means the brain of the company is also drafted in a wrongful manner. Think and answer, ma. Can Harsha become a shareholder of the company? Yes. Yes or no? He's not drafting it. He can become a shareholder. Can he become a subscriber? No. Restriction is only on the subscriber because he is drafting this entire document. I don't want him to draft it. Can he become a shareholder later part? Yes. But he shall not be a subscriber to memorandum. This subscriber to memorandum shall be guilty of fraud or shall not be guilty of fraud. But is it possible for the CRC to come and check whether you are a fraud or not? No. Give a declaration. Make a promise. Make a promise that you are not guilty of fraud. Make a promise that you have not been convicted. Convicted means? What do you mean by convicted? You have been guilty of an offense and that offense have been charged with imprisonment. If, for example, you were crossing a red signal, say you are driving your car and you did not wear a seat belt. Is it an offense? Yes. For which you will be put in jail for 10 years. You have committed an offense, you are guilty of an offense, but you will not be punished with imprisonment. You will not be called as convict. Or take in any of our politicians. I don't want to take a specific name. Every politician has gone through this already. It has not been proven that they have done wrong, but they'll be put behind the bars for a certain period of time. Will they be called as convict? No. No. Unless it is proven that they have done a offense, it is guilty of offense and been imprisoned, then he is called as a convict. Arvind Kejriwal, was it proven? Liquor scam. Liquor scam, heard about it, right? Arvind Kejriwal, was it proven? No. But was he put behind the bars? Yes. Couple of years back in our state also, Andhra Pradesh, what happened? Chandrababu Naidu was put behind the bars, but was it convicted? No. It was not proven. If it is proven that you have done something wrong and you have been charged with imprisonment, then you are called as a convict. If you are a convict, that means you have done something wrong in the past. Done something which is wrong, which is as grievance as that, you should be put behind the bars. You are not allowed to incorporate a company. You cannot become a subscriber. You cannot become a first director. Give me the second declaration. The subscribers to memorandum and the first directors giving declaration that they are not convicted, they are not guilty of a fraud, and the documents they have submitted are all correct. Correct documents have been submitted. Now try to understand the reason behind it. If compliances are not correctly done tomorrow morning, who will be blamed? Subscribers or experts? Experts. If the documents are not correctly prepared, will the cost accountant be blamed? No. Who will be blamed for that? Subscribers and which director? First director. That's your second and third point submitted. That was a difficult part, Amma. I mean, difficult in the sense you already know this. I just had to add the logics behind it fast, Amma. Who is submitting documents fast? Where are we? Section number? What is it called? What are we doing actually? Registration. Who is submitting documents? Subscribers to memorandum. Submitting documents to the CRC will verify or directly incorporate. Verification is prima facie or conclusive. There's a chance that the documents might have misstatements but will not be found out by CRC. Hence, we are asking them to submit declarations. The first document submitted is MOA and AO. Obviously, the word subscriber, that means they have signed it. Who have signed it? Signed by all the subscribers to memorandum. Then second point, a declaration. Declaration given by the experts stating that they have complied or not complied. Complied with the provisions of Companies Act for incorporation of company. Then third point, declaration given by the who? About documents, subscribers to memorandum and first directors. How will I become first director if my name is mentioned in the AOA? I'll become a first director. Subscribers and first directors have given 3 declarations stating that they are not convicted, stating that they are not guilty of a fraud, and stating all the documents they have submitted are correct. Correct documents have been submitted. Given by whom? Subscribers to memorandum and first director. Now imagine yourself as CRC from here. Once these 3 documents have been submitted to you, if you have a doubt in any of these documents or you want additional information on this or additional explanation on it, can you ask it? Whom will you ask? Company? The company is not yet incorporated. Who will you ask? I have 10 subscribers. I'll go to each subscriber's home and ask. I should have a point of contact. That point of contact is basically your concept of registered office. In the future, once a company has been incorporated, the company will have a point of contact called as registered office. That's where all documents will be sent. That's where all communications will be sent. That's where all legal documents will be maintained. But as of now, is a company incorporated? If the company itself is not incorporated, it will not have an address to it. I want a temporary address for your company for this communication purpose. The temporary address is called as address for correspondence. What is it called? Address for correspondence is temporary or permanent? Temporary only until the company has established its permanent address. What is its permanent address? Registered office. When is the registered office established? After incorporation. Until that point of time, I want you to give me a temporary address called as address for correspondence. Correspondence is nothing but communication. I want an address for communicating with you until the company has established its permanent office. Give me the wordings here. What's the fourth document submitted? An address for correspondence until the registered office is established. Don't get this misinterpreted. Not until company is incorporated. Once the company is incorporated, it will take time for them to establish the registered office. Until registered office is established, until your permanent address is established, give me a temporary address. Wordings are address for correspondence until the registered office is established. Once the registered office is established, can I dismantle this? Registered office, permanent or temporary? I should have registered office until company goes into liquidation. Can I change it from one place to another place? Can I discontinue, close it? No. I cannot close my registered office, but I can change it. We'll discuss more on it later part, but this is point number 4. Point number 5 and point number 6 was straightforward. If you have been accepted as a company, I want your details in my registers. Particulars of subscribers to memorandum, particulars of the first directors. Next 2 points. Point number 5 and point number 6. What is point 5 and 6? Particulars of whom? subscribers to memorandum, and the particulars of first directors. 6 documents have been done. Give me these 6, I'll add the 7th point. 7th point is technical in nature, it will take time for you to understand. Give me the 6 points quickly, Amma. Close your books and give me the 6 points. Where are we? Section number. Very fast, Amma. Who is submitting? For a private company, it must be at least. Public company, at least. Submit documents to the central or jurisdictional. Verify or will not verify. Prima facie or conclusive. Then they'll incorporate you as a company, but you have to submit documents. What documents have to be submitted first? MOA and AOA. Then declaration by the experts. Compliance or documents? Compliance, that they have complied with the Companies Act for incorporation of a company. Third point, declaration given by subscribers to memorandum and first directors, giving 3 declarations stating that they are not convicted, they are not guilty of fraud, and they have submitted all documents which are correct. Correct documents have been filed. Then because these 3 documents have been submitted, I'll have doubts in it. I want a communication process. Address for correspondence, temporary until registered office have been established. Then last 2 points, particulars of particulars of the subscribers to memorandum and particulars of the first directors. 6 points have been submitted. Any doubts until here? No. Completely outside the box, not section 7 concept, but they have added the 7th document. Let me clarify that for you. Forget about everything else, just focus on a couple of examples here. Company is a separate legal entity. Company is run for whose benefit? We have done this. It is a democratic entity. It is run for shareholders. It is of the shareholders. It is for the shareholder. It is incorporated or it is existing by the shareholders. It is a democratic entity. It is run for shareholders, but it is run by whom? Board of directors. We, the board of directors, will manage it, but for whose benefit? Shareholders. Now imagine you, the board of directors, you, the group of directors, board of directors, will manage the finances belonging to the shareholders for their benefit. You're acting as principal or agent? Be very careful with this answer. You are agent of. Very good. Company. You're not an agent of the shareholder. Shareholders are principals, but who is the agent? Company is the agent. Are we getting the linking between them? Shareholder is a principal. For this principal, who will act? Company, agent. But company is also a principal for the board of director is an, company is an, shareholder is an, company is an. Company acts as an principal as well as agent. Come back. Now if a company has been incorporated, you are running it for whose benefit? Shareholders' benefit. You have to take decisions for whose benefit? Shareholders' benefit. Now you as a board of director, say assuming have 2 options here. Machine A and machine B. How many options? I'll give it simple on the example. 2 machines are there. Both the machines are having same production capacity. Both the machines consume the same amount of electricity. Both the machines will have the same running cost. Both the machines will require the same raw material and will give you the same amount of finished good. Everything is same about both the machines, but machine A is going to cost you rupees 10 lakhs, machine B is going to cost you rupees 12 lakhs. Which is better? Why 10 lakhs? Because it's going to reduce your total cost, indirectly benefiting whom? Shareholders. The company will get benefit out of it because of your decision. But this machine B was sold by your relative. What decision will you take? Machine A or machine B? Still machine A? Because it has to be, you hate relatives, that's why machine A. You'll still choose machine A. Whose benefit? Shareholders' benefit. Machine B is sold by a company which is owned by you. You own the company. You own the company who is selling machine B at a cost of 12 lakhs. That means it is profit for your company. Profit for your company means indirectly profit for you. Now tell me, machine A or machine B? There's a chance that, I'm not stating they will happen, there's a chance that some people will go for machine B. That will benefit the, not benefit the company, it will benefit the director. Now try imagining this topic. For every single director, he has two perspectives. One, the company's benefit, company's interest. Second category, he'll have his personal interest involved. If at all he has his company's interest and personal interest both involved in it, there's a high chance that he'll be leaning towards personal interest. Indirectly loss for the company. Are you getting these two words clear? I want these technical words. I'll use them later in a very good section is drafted on this. Company's interest and personal interest, which is to be given importance. But if at all you are falling in that situation where you have company's interest and personal interest both existing, there's a high chance that director will always lean and enter into a contract for his personal interest, which is indirectly lost for the company. Now think and answer. Can I have personal interest? Yes or no? If I have personal interest, I'll make indirectly decisions which are detrimental to the company, loss making to the company. But if I ask my director not to have personal interest, nobody will act as director. You'll not find a single director also. Then companies had stated that, okay, fine, have personal interest if required. Have personal interest. But if a situation arises where your company's interest and personal interest are not in line with each other, they are opposite to each other, contrary to each other, step aside, don't participate in that meeting. Don't participate in that meeting. Rest of the directors who don't have personal interest will take care of the decision making process. Can you have personal interest? Yes, I cannot restrict it. But if you have personal interest, you have to. You shall participate or shall not participate. Shall not participate. Step aside, let the rest of directors take care of it. Give me a conclusion on it. Do we have company's interest? Obviously, we have to work for the company. We also have personal interest. If you don't have personal interest, do we have a problem? You'll work for whose benefit? Company's interest. But if you fall in a situation where you have personal interest as well as company's interest, can you participate? Can the other directors participate? Sure. Wait there. How would I know in which entities you have interest? How would the company know whether you have interest or not in a company? This is very common for Companies Act. If I am not in a position to find it, I'll ask you to declare it. If I am not in a position to come verify it, I'll ask you to come and declare it. So what's going to happen? Who should disclose it? Director. Director has to prepare a huge list of every single entity in which he is having a personal interest, give it to the company. That interest disclosed by the director have to be submitted to the CRC. To know the real meaning why this company got incorporated, CRC wants to check all these interests of the director. Are we getting the logic clear, Amma? Who should disclose? Director has to disclose every single, very careful word, entity. It can be a partnership firm in which I am interested. It can be a sole proprietor in which I am interested. It can be a company in which I am interested. I don't use the word company, I use the word entity. Who is having interest? Is having interest in a entity. He will disclose it to the company, and this disclosure is also being filed with this CRC here. The particulars of interest of all the first directors have to be filed. Filed with whom? CRC. We have a separate section for this later part. Section 184 of the Companies Act talks about it. Section number 184. Before we jump into next procedures, I want this 184's mindset clear. Can I have personal interest? Having personal interest is allowed or prohibited? Allowed. I'm not going to restrict it. You can have personal interest. But if you have personal interest, you should participate or shall not participate. How would I know whether you have personal interest or not? You have to disclose. So what is important under Companies Act? Not having personal interest or disclosing personal interest? Disclosing is important. You can have it, but come on, disclose. Once you have disclosed it, can you participate it? Can you vote? Can you vote on it? No. Can you participate in this meeting? Can you discuss matters? Can you influence other board of directors? No. You can have personal interest, but you're not allowed to participate, but you have to disclose. That's where the section 184 gets its heading. disclosure of interest by directors. Are you getting the point clear? Have interest, but at least come and disclose it clearly. I am satisfied with it. We talk about prohibition on interest or disclosure of interest. Disclosure of interest. If you have interest, it's fine, but those interests of the first directors have to be disclosed. And now here it has to be submitted to the CRC. That is when the document submitted. Now once all the submission process is done, there comes the next logic. Quickly run through the same chart we have drawn. This is easy to complete fast. Once it is submitted, if the CRC is satisfied, they'll incorporate you as a. What's the proof that you have been incorporated? They'll give you a certificate called as Certificate of Incorporation. Who is giving this certificate? CRC is giving Certificate of Incorporation stating that the company has been incorporated. This Certificate of Incorporation will contain a specific date. The date will give you indication that the company got incorporated from that particular date. Your company doesn't come into existence on submission of documents. Your company comes into existence on the date which is mentioned in the Certificate of Incorporation. And the certificate will act as a conclusive evidence that the company is incorporated. Prima facie evidence or conclusive? Verification was done, prima facie. But once you got the certificate, it will act as a conclusive evidence that the company has been incorporated. What is this document called? Certificate of Incorporation, which will contain a date. It will have your SIN number. What is SIN? Nothing but Aadhaar card for the company. Identification number for a company. Corporate identity number. It's a combination of alphabets and numbers. It's a combination of 21 alphanumeric numbers. Alphanumeric digits we call it as. Alphanumeric digits. What do you mean by that? Your Aadhaar card. Remember? Aadhaar photo. How can we forget Aadhaar photo? Remember Aadhaar photo? Aadhaar number? No. Aadhaar photo we remember. Aadhaar number is only digits, only numbers. Your PAN number, alphanumeric. It's a combination of alphabets as well as numerics. Same thing, 21 alphanumeric, which is, I will explain it here, wait. 21 alphanumerics, the first letter is L or U. What's it? L or U, defining whether you are a listed company or a unlisted company. L or U. If it is U, it is unlisted. If it is L, it is. Then we have 5 numbers which are going to define the industry in which you are incorporated. They'll define the nature of business of your company. It is defining the industry. 5 numbers will be there. Then afterwards, we'll have 2 alphabets which is going to define the state in which you are incorporated. It will be called as state code. For Telangana, TS is gone. They have modified it to TG now. Andhra Pradesh, AP. It will be a state code. Then after the state code, we have again 4 numbers. 4 numbers which is going to define the year of incorporation. The year in which the company got incorporated. First, LNU talks about listed or unlisted. 5 numbers which is going to give you the industry code in which you work under. 2 alphabets which is going to define the state in which you are incorporated. 4 numbers again which is going to define the year of incorporation. Then we have 3 alphabets which is going to define the type of company you are. PTC, PLC. PLC, public limited company. PTC, private company. We have 3 alphabets defining the different type of company you are. Then after 3 alphabets you have, how much is done? 15, right? Then the next 6 numbers is basically your serial number, which is called as registration number. Serial number is basically the order in which your name is entered in this register of company's book. Serial number of the company. That is your 6 numbers called as registration number. Put them together fast. Start. First, L and U is called as listed or unlisted. Then second part. 5 numbers which will define your nature of the industry. Then next, 2 alphabets for state code, then 4 numbers for year of incorporation, then 3 alphabets for defining whether you are which type of company, private, public, government, etc., GOV, etc., everything will come there. Then we'll have 6 numbers for defining your registration number. Get this number. Just define what type of company is this. Listed or unlisted? What's the industry code? 17110. Which state? Maharashtra. Which year? 1973. It is PLC, that means it is a public company. What's the registration number? 19,786. It was a 19,786th company in Maharashtra. Reliance Industries. SIN number. Can you identify, what can you identify just by SIN number? You know? We can understand whether it is a listed company or unlisted company. We can understand the industry in which it works. Industry code, you can just put it in the Google, you'll get the industry code. The business it works, and you can define the state in which it is incorporated, you can define the year of incorporation, you can define the type of the company, and get this also. Which company? Unlisted company. Where is it incorporated? Maharashtra. Which year? Which type of company? And the registration number is 478. It is Tata Sons, one of the biggest companies in India. It is still a private company, Tata Sons. Tata Group is listed, Tata Sons is unlisted. Last point I want to define it, we'll close it off on this. First, which company? Industry code 16005. Which year is it incorporated? 1910. Which state is it incorporated? It is a public company or a private company? And the registration number is 001985. ITC. What is ITC? Indian Tobacco. We'll discuss the full form later. Once the documents have been submitted, you'll get the certificate of incorporation. Come back to this certificate. We'll have the date, we'll have the SIN number, we'll also mention the name of the company. Forget this as of now, I'll add logics in this in a bit. This document will act as a conclusive evidence or prima facie evidence. Conclusive evidence that the company has been incorporated. Any doubts until here? Clear on this? Now, last possibility. What happens if you have submitted false information? If you submit false information, will you be punished? Yes, will be punished, and you know this. Whenever you have any fraudulent activity in Companies Act, we'll jump to section number 447. What is 447? It is not fraud, amma. Fraud definition is different. 447 is punishment for fraud. You will be punished under section number 447 if you have done a fraudulent activity. Same topic here. If you have submitted any false information, any incorrect information, you will be punished under section number 447. What is 447? Punishment for fraud. That's your section number 7, incorporation of company. Indirectly speaking, we have done incorporation or registration. Registration. Again, this is not full concept completed. Let's start with actual incorporation process now. Incorporation doesn't happen by submitting documents to the CRC. Where does incorporation process start is by, heard about this, right? SPICE plus. What is SPICE? SPICE, simplified proforma for incorporating a company electronically. Today, companies incorporation happens physically or electronically. Now we are submitting documents to CRC. That doesn't mean that you have to go to Gurugaon. You don't have to go to Haryana to get incorporated. Sitting at the comfort of your home with your mobile phone, you can incorporate a company. It is all electronic today. We have simplified the process of incorporating company by a process called as what? SPICE. What is SPICE? Simplified proforma for incorporating companies electronically. Now, how simplified is it? We'll discuss that tomorrow. We have a concept called as Agile Pro. We'll discuss that tomorrow. But I want a clarity on incorporation process. The incorporation process is of two parts. Part A and Part B. Whatever documents we have submitted today are not Part A, they are Part B. what actually happens for incorporation of company is that you have to get a name reserved first. The reservation of name happens in part A. Once the name is reserved, then you will be allowed to submit documents. Once the documents have been submitted, then you will get incorporated as a company. Now, if I use the word part A for reservation of name, you know this word, so I'll be a little quick on this more. Reservation of name is temporary in nature. I'll give you a name only for a temporary period. Within this temporary period, submit all the documents correctly under part B. If you have submitted them correctly, then I'll incorporate you as a company and I'll give you this name permanently. That's where the word allot is used. Reservation of name and allotment of name. First, what will happen? Reservation or allotment? Temporary or permanent? Temporary. And you are now supposed to submit all the documents under part B. If documents of part B are correctly submitted, then the reserved name will be allotted. But that means by the time you get this certificate of incorporation, you already have a name. Yes. By the time you get the certificate of incorporation, by the time you're submitting these documents, you already have got your name reserved. What does happen first? Submitting documents or reserving a name? Reserving a name. That means reserving name also happens before incorporation. Start the process. Who will submit documents? Subscribers will make an application to the, because entire registration process is now in the hands of CRC. This also will be taken care by CRC. So who is going to make application? Subscriber to memorandum will make an application to the CRC requesting the CRC to reserve a name. Reserve it or allot it? Reserve it first place. I'll make an application. Once this application has been made to the CRC, CRC will verify application or directly incorporate? Verify. After verification, how to verify, I'll come to that in a bit. After verification, if they're fulfilled, if they're satisfied, who is submitting? Documents or application? Documents or application? Application. Application for what? Reservation of name. The CRC will verify or directly allot. After verification, they'll allot or reserve. Reserve is only for temporary or permanent. Then after reservation, you will be given a temporary period within which you have to submit documents. Documents under part? How many documents? We just discussed this. How many? 7. These documents, once they have submitted as per part B, if they are satisfactory in nature, then the name will be allotted. What do you mean by name being allotted? They are giving you a document called as certificate of incorporation that will come with your name. Is the flow clear? If the flow is clear, we'll expand the chart. Who is submitting first? Before or after incorporation? Application or documents? This is part A or part B? Reservation or allotment? Application to the CRC. This application will contain a request for reserving a particular name. If this application has, try to get the words clear, if this application has a defect in it, I'm not stating it has false information, it has a defect. Some document was missing, or the document was not able to be read correctly, or the document was insufficiently submitted. I did not bluff the CRC, but I forgot to submit a document. It is called as defective. If it is defective, will they reject it? They'll ask you to resubmit it. They'll not reject it completely, they'll ask you to resubmit. They'll give you a second chance because you have not done any mistake here. They'll ask you to resubmit. They'll give you an extra time of 15 days to resubmit it. How much time? If it is defective, you can resubmit it within how many days? 15 days. Once it is submitted to CRC, the name might change. ROC, CRC, but all of them have the same character. They are still money minded. Are we required to pay fees? Fees is mandatory or optional? Mandatory. Without fees, will they accept these documents? ROC is money minded. CRC is also. They fall under the same family tree. They're all same category. They will be asking you fee. Without fee, will they accept this document? No. Then they'll verify the document. After verification, they will reserve it or allot it. Reserve temporary or permanent. In this temporary period, you have to submit all the documents under part. Once correctly submitted, the name will be reserved or allotted. That means it is given permanently to you. And I'll communicate through my document. Certificate of incorporation. The certificate of incorporation will come with couple of information in it. What information will be mentioned in the certificate? Then we still have to expand this more. Let's complete the certificate first. It will mention the date, it will mention the SIN number, it will mention the name of the company. Name, if it is mentioned in this document, that means name is allotted. And they'll also give you the PAN number of the company. You don't have to apply it separately. You'll get everything in this itself. You'll come to this. We'll understand this logic in agile topic. We'll come to it. Expand it. Verify. Who will verify? CRC. CRC has to verify stating this is to be understood. Wait a second. If this is understood, then you'll understand the expansion of section 4, section 16 and section 13. Three concepts are depending upon this logic. This will be the origin for next three sections. This has to be very logically understood. Who is submitting documents? Subscribers, to whom? CRC. CRC has to verify it. CRC has to verify that the proposed name of the company is not identical with an existing company. If it is exactly identical, exactly same, can I allow that company to be incorporated? Can we incorporate Tata? Allowed or not allowed? Can we incorporate Reliance, Wipro, Infosys? If I incorporate such company, people will assume that we are the same company, and it will be a loss for public as well as the existing company. Can I incorporate a company with an identical name? I cannot incorporate a company with identical name. Can I incorporate a company with similar name? Can I incorporate Puma? Yes? Yes or no? Yes? Technically no, Amma. If it is giving impression that it is connected with the previous company, it is not allowed to be done. But again, don't ask me questions on this. I know there are brands out there who call themselves as, but they're not registered as companies. They're simply putting a brand name on it and selling it. They're not registered as companies. They're not allowed to be registered as companies. Give me the wordings here. Who will verify? Will verify whether the proposed name of the company is identical or similar. Too nearly similar with an existing company. What are the two words you remember? Either it is identical or similar. Too nearly similar. Can I incorporate Reliance? Spelling is correct. L-A-O. No? Can I incorporate Reliance company? Can I incorporate Reliance? Identical. It is not identical, but it is too nearly similar. It is either too nearly similar or it is identical. This is not allowed. Who should check this? CRC. CRC will verify the first point. Second point. The documents you have submitted, can I start Indian Terrorist Organization Private Limited? No. Can we start such company? Yes. Can we start Kidnapping Private Limited? No. Yes. Can we start Cheap Drugs Private Limited? Allowed? Why? You will not find this company in India. Don't try to search for it. You will not find this company. They're not identical. They're not too nearly resembling. They're not too nearly similar or resembling, but they are offensive under an act. Not maybe Companies Act, but they're offensive under any act in India. You cannot incorporate such company. Can you incorporate a company with a name which is creating disputes between religions? No. They're called as offensive. Offensive under which act? Any act in India. If they're offensive under any act in India, such name shall not be allowed. Who will check all this whether it is offensive or not offensive? CRC. Given the wording somewhere, it shall not be identical. It shall not be too nearly similar. They have used the word resembles, too nearly resembles, or it shall not be offensive. Third case. Can I start the company Income Tax Collections Private Limited? Or Income Tax Recovery Private Limited? Recovery sounds better. Income Tax Recovery Private Limited. We'll start recording income taxes. We'll give them discount. Not allowed. Allowed? Not allowed. Why? This type of company's name is giving impression that is connected with the government. If not all, few of them might be fooled that this is actually a government entity. Can a company's name give impression that it is connected with the government directly? No. It shall not give an impression that it is some other way, directly or indirectly, connected with either central government or state government or even a local authority for that matter. If it is giving such kind of impression, it is called as undesirable. What is it called? Undesirable in the opinion of central government. Give me the proper wordings now. Who is verifying all these 3 points? CRC shall verify whether the name of the company is identical or too nearly resembles. Second, CRC has to verify whether the name of the company is offensive under which act? Companies Act or any act? Any act. Then the CRC has to verify whether the name of the company is undesirable in the opinion of central government. What do you mean by undesirable? It is giving an impression that it is connected. Connected with whom? Central government or state government or local authority. If it is giving such kind of impressions, it is called as what? Undesirable. After verifying all this, if the CRC is satisfied that none of them have been satisfied, then I can reserve. Who will reserve it? After verifying how many points? No sentences, only keywords. Identical or too nearly resembles. Second point. Offensive. Third point. Undesirable. In whose opinion? Central government. But what do you mean by undesirable? It is connected. It is giving impression that it is connected. Connected with whom either? Central government or state government or local authority. Give the descending order. Central, state and local authorities. If after verification I have satisfied that none of the 3 points are satisfied, then I will reserve your name. Once the name is reserved, the picture doesn't close here. You have to submit documents. Submit documents as per part B. You have been given a time limit of 20 days to submit these documents. What's the temporary period given to you? 20 days. Submit all the documents in 20 days. But we know, if at all we had to submit documents in 20 days, we'll be on time. We'll be on time exactly 20 days. We'll start collecting documents on the 20th day. We'll not start it now if you have 20 days. You'll start collecting it on which date? Will 20 days be sufficient for us? Are we lazy? We are very lazy. 20 days is sufficient or not sufficient? But if 20 days, if you are not able to submit documents in 20 days, the name reserved will be allotted or cancelled. Not cancelled, not allotted. Why? Listen. Not only you, CRC also have put in efforts to come till this far. You have submitted documents, etc. That's all fine. But who has also put in efforts for this process to complete? CRC. I don't want my efforts to be wasted. What will happen to you? You will make application tomorrow morning again. I have to start the process again from the beginning. I'll be a generous person. I'll give you extension. If 20 days is not sufficient, I'll give you an extension. You can submit documents even after 20 days. But don't get much fooled. I'm still money minded. I'll give you extension, but I'll charge fee. You already paid fees at the beginning part. Now I want additional fee to be paid. What's the original time limit given to you? 20. If this 20 is not sufficient for you to submit documents, you can apply for an extension. This extension I'll give you another 20 days. Extra 20 days will be given, but pay fees. Pay rupees 1000 as fees. Submit documents within 20 with the original topic. If the 20 is not sufficient, you can get an extension of how many days? Another 20, making it a total of how much? 40 days, but payment of rupees 1000 as an extra fee, additional fee. If this 20 is not also enough, I'll give you another extension. I'm very generous. I'll give you another 20 days of extension, making a total of 60 days, but I'll charge 2000. Am I generous? Accept it, otherwise I'll not give you extension. First extension for how many days? 20 days. How much fees? Second extension for how many days? Next 20 days, another 20 days, but you have to pay how much? Any which ways ROC is going to give you, CRC is going to give you extension. Will you file it within 20 days? Then after 20 days, they'll give you another extension. This extra 20 days. Not for the entire 40 days. After that, after the 20 days extension also, it will be rejected. So how many extensions will be given to you? What's the original time? Pay along with the original fees. If not, for how many days? 20 days payment off. For another extension, you will pay 2000. But this, they've made a small amendment into this for people like us. We'll realize that you have to submit documents when? On the 20th day. Can we submit documents in the first 20 days? Obviously, no. Then we'll go to the ROC, CRC. We'll request them. CRC, we want extension of days. CRC states that I'll give you extension of how many days? Sir, we didn't even know what documents to submit. We have to prepare it now. Will take more than 20 days. We requested CRC, why 20 days? Because I know I am very talented. I'll not submit documents in 20 days. I'll after 20 days again come to you for another extension any which ways. Give me a single extension for 40 days. You can apply for one extension for entire 40 days at a time. CRC is happy, they'll get more money. How much will they charge? 1000? They'll charge the entire 3000 at once. Options. Give me a multiple options. Submit documents within 20. If not, you can apply for an extension of another 20 days on payment of. Or you can directly apply for an extension of 40 days on payment of 3000. If this 20 days is not sufficient, you can apply for another 20 days on payment of. Then after that, the document will be rejected. In total, you are given a maximum time of how many days? 60 days. Submit all the documents of Part B. Once everything is submitted, name will be allotted. Allotted means permanent. If it is allotted to you, can this be allotted to any other person? Forget about allotment, it will not even be reserved. Because it's going to be identical to a name of the company which is existing now. It will not even be reserved anymore. Once it is allotted to you, it will be permanent, it will stay with you until you go into liquidation process. Any doubts until here? Expand it. We are not done with the chart. Who can make application to who will make application to CRC for name? Subscribers. What happened is, think about it. Blinkit. You know this company, right? It was not the original company's name. Initially, it was called as Grofers or something, if I'm not wrong. Heard about it? No. Grofers, right? It was initially called as Grofers, then it got changed. They changed their name to Blinkit. That means they've got a new name reserved. Who applied? Subscribe. Company is already existing. Not shareholders. Shareholders don't have anything to do. Who will? Separate legal entity. You have done this phosphorus hard bottle. Who will make applications? Company. Who makes application? Which company? Existing company. Here, who is making application? Subscribers to memorandum for what type of company? Proposed to be incorporated company. Now this time who made application? An existing company made an application to the CRC for a new name, for a change in my name. So 2 people can apply. Reservation of name can be done by 2 category of people. First option and the regular option is subscribers to memorandum. For which type of company? Proposed to be incorporated company. Or second, who can also make application? An existing company can make application for change. Do they already have a name? Have they gone through all this process at the time of incorporation? Yes, but they want to change it. Can they change the name? If they want to change it, they'll make application to the CRC. Entire process will be same, except that because it is a company. Think about it, Amma. If it is already a company, they have to follow rules and regulations. They cannot change name as and when they want. They have to conduct a general meeting. They have to pass a special resolution. They have to get approval from central government. There's a procedure to be followed. Will that procedure take time? Subscribers to memorandum. Are they a company? Are they applicable with companies at yet? Do they have procedures to follow? Do they have formalities to follow? 20 days is sufficient for them. But if it is an existing company, I am a company governed by my Companies Act. I have to follow certain formalities to do this process. Will it take more time for me? Will that 20 days be sufficient for me? I'll directly give you 60 days. Which company? Existing company will get the name reserved for 60 days and proposed to be incorporated company. The subscribers will get it reserved for 20 days. How many days for existing company? I'll reserve it for 60 days for an existing company. If this 60 days is not sufficient, you can apply for an extension, but payment of. I'm not money minded always. I gave you extension already. The 60 days I have given you was a time period including extensions already. Don't come back and ask extensions. Extension topic applies only when who is making application? Subscriber to memorandum. If application is made by an existing company, they're already been given extended time. 60 days. Can they extend it again? No. Subscribers? Can they extend it? Yes. For existing company, there's no topic of extension. Any doubts in this? Clear? We have done with the reservation of name. I'll give you the section number of this later part. I hope you are able to imagine this chart without being shown what's happening here. Quickly run through the basics of the chart, not entire details. Subscribers to memorandum or an existing company will make an application to the CRC will verify or directly allot. After verification, they'll reserve or allot. Reserve is temporary or permanent. Submit documents under part. Then the name will be by mentioning the name in the certificate of incorporation. Any doubt? All this verification process of CRC is done on a prima facie basis or conclusive basis. There's a chance that the document might have misstatements. Document might be having false information. But who could not find it? CRC. Try to answer this. If the documents had a false information in it, whose mistake? CRC. You would draft false information and blame it on CRC. If the document has false information, whose default is this? Subscriber's mistake. I could not verify it fully because I never had been given time. Are you getting the logic clear? False information was mentioned in this and the company's name got reserved. Allotted or reserved? Whose mistake? Whose mistake? Blame it on CRC. You gave fees to him, he's the default. Whose default? Subscribers. Now CRC states that if you are trying to bluff me, will he sit silent? He'll impose punishments upon you as a company or as a group of people. Who will impose punishments? Who will impose punishments? CRC will impose punishments on subscribers where the name which is reserved, will it be allotted? No. If not allotted, we use a logic, the name reserved will be cancelled. Spelling might be wrong, Amma, ignored it. I don't think I gave this disclaimer in the classroom. Spellings will be wrong. You should not correct them if they are wrong. If you know the spelling, you can write the spelling. If you don't know the spelling, assume that the spelling I've written is correct. But don't question me, don't disturb the flow of the answers. There will be spellings mistaken. There will be there. I'm not stating that there might be sometimes. Every day you'll find a spelling which is mistaken. Most of the cases, if I don't know the spelling, I'll simply write this. That's how we have passed. So spellings will be mistaken. Don't question on that. And drawings, you might have understood it. I'm a great artist. You might not understand the talent of mine, but I am a great artist on that part. You have to adjust. You have to reach my talent to understand the drawings. So that's one thing. Spellings are one thing. Drawings, I'm an artist, I know that. We'll have some more disclaimers later part, but spellings will be wrong, Amma. Don't question them. Okay. CELLD or will be called as what? Name is allotted or cancelled. That's a concept called as cancellation of name. If the documents are correctly submitted after reservation, what should happen? The name should be allotted. But if you have submitted false information, your name will be not allotted, name will be cancelled. Is it fine? Next topic. You have submitted correct information. You have submitted false or correct? Correct information. You are a very genuine person, are you? At least be confident on the example. You are innocent. Put your innocent faces. You are very innocent. You are very genuine. Will you submit false information? No. Even in our dreams, we will not submit false information. We submitted true correct information to the CRC, but the CRC failed to verify this. Whose mistake? Now CRC comes to you and starts blaming you, shouting. If CRC can shout, we can also shout. We'll take a chair and throw on the CRC. Whose mistake is this? Can he come and shout on us? Previous example, I agree. It was whose mistake? Our mistake. If CRC shouts and imposes a punishment on me, I'll accept it. But this time, whose mistake is it? Can CRC come and impose punishments on me? But the company has been incorporated with a name which is identical with another company. If it is already incorporated, CRC's mistake is there, I agree. But if it is already incorporated with the name which is already identical, can we continue? Okay, fine, mistake happened, let it be, we'll check it next. No. The existing company will be affected. Then comes the central government to pass an order. CRC will not pass order. If CRC comes and imposes an order on me, I will not listen to it. You have made a mistake, I will not going to listen to you again. But who comes down? Central government comes down and states that your name has been already drafted. I will ask you to rectify your name. A concept called as rectification of name. What happened? What's happening here? Whose mistake? CRC's mistake. Who was innocent in this? We the subscribers. Can the CRC pass an order? Who will pass the order? Central government. A logic called as rectification of name. Rectify your name. Cancellation, rectification are two different topics. Cancellation, whose mistake is that? Subscribers. Who will pass the order? CRC. But if it is rectification, whose mistake is it? CRC. Who will pass the order? Nowhere in the law they'll mention that CRC made a mistake. Obviously, if it's their law, company law, will they mention that CRC made a mistake? But they have given this concept, section 16, called as rectification of name, where CG comes and passes an order. But this situation arises because who made a mistake? But will they mention it? But are we fools not to understand it? Applying the logic, we know that they have made a mistake. But have they mentioned that they have made a mistake? No. But who will pass order here? A concept called as what? Rectification. Last process. You have submitted documents correctly. Correct information. CRC also verified it correctly. Is there any problem? First example, whose mistake? Second example, whose mistake? Third example, whose mistake? No one. No one is at mistake. The name got reserved, name got allotted, everything is fine. After a couple of years, I want to change my name. Can I change? Whose mistake is it? This is a concept called as alteration of name. Three concepts more. Cancellation, rectification, alteration. What is this we have done? Reservation of name. From this reservation, we'll have three different logics which will come arise. Cancellation, rectification, section 4, section 16, section 13. Three different topics will come arise. Any doubts on that? I have not started any of them, Mama. Cancellation, rectification and alteration, we have not started any of them. We'll start it tomorrow in next session. Any doubts in these three headings? I told. Give me just briefing of it. If subscribers are at mistake, nobody is at mistake. If central government is passing order, rectification, the documents are falseful. Wrong documents, false documents were submitted. Cancellation, correct documents were submitted. Think. It can either be rectification or it can also be alteration. If ROC failed to verify, CRC failed to verify it correctly, rectification. If ROC is passing order, ROC in the sense CRC is passing order, cancellation. If company wants to voluntarily change it, it is mandatory to change it. Cancellation and rectification. They'll ask you to change your name. I'll come to that in a next class, but they have 3 topics we'll have to discuss from here. One is called cancellation, second is called rectification, and then we have alteration. All of them are 3 different sections. Cancellation, rectification, and alterations. Any doubts on this? What sections have we done today? Section 3, formation process, then section 3A, where we had 6 months topic. Then we have done section number 7, talks about incorporation. From the section 7, we have done reservation of name. I'll give you the section number later. Reservation has a separate section to it. I don't want to skip the flow of it. Reservation of name. From there, we'll tomorrow start with what? Cancellation, rectification, and alteration. Any doubts until here? We'll continue tomorrow. Thank you, ma'am.